Good morning. This meeting is called to order. The record, the time is 1:30 p.m. The day of the week is 2/18/25. The commission and staff are appearing from Helena, Montana, in the Bowling Room of the Montana Public Service Commission. I am Commissioner Brad Molnar. I'm the presiding chairman for this meeting. Please join me in reciting the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. For the record, the following commissioners are present. We have Commissioner Wellborn, we have Commissioner Pinocci, we have Commissioner Bukasek is attending online. We have Commissioner Fielder and myself. Therefore, we have a full quorum of 5 commissioners. The Public Service Commission welcomes any comment on any item that is on today's agenda or any matter that is within the jurisdiction of the Montana Public Service Commission. Are there any public commenters in the room? Seeing none. Are there any public commenters online? Indicating none. Are there any announcements or changes to the agenda? Not aware of any. Therefore, I will move for approval of the minutes.
Mr. President, I move adoption of the minutes for the week of February 10th, 2025.
Thank you, Commissioner Fielder. Do I hear a second?
I'll second.
Thank you, Commissioner Wellborn. So we will start today's work session.
Mr. President,
Yes.
point of order. We have to have discussion and a vote on the motion.
Oh, getting ahead of myself. Is there any discussion on the minutes as prepared? Seeing none. All in favor of adopting those minutes, say aye.
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 And those opposed, similar sign. Seeing none. So we're going to actually start our work session now. The items as listed are we have the commission initiated amendment of the Montana Administrative Rules 13.3.405 and 38.3.406 to consider the draft notice of proposed rulemaking to change the signature required for motor carrier protests from a notarized signature to a verified signature. Yes.
Good afternoon, President Molnar and commissioners. My name is Amanda Webster, and I'm a staff attorney for the commission. Staff recommends approving the draft notice of proposed rulemaking that is before you to start the process of amending the 2 rules you stated. Staff recommends that these rules be changed to require protests to be verified instead of notarized. This will match the verification requirement for motor carrier applications and will make the protest process more efficient for protestants. Verification in this context means that protests will still be signed and confirmed as true and correct under penalty of perjury. This proposed rulemaking will eliminate the need for protests to be signed before a notary public. If approved, staff will prepare the notice for submission to the Secretary of State's office for publication in the Montana Administrative Register. Then there will be a 28-day public comment period for interested persons to submit their views or request a hearing. Then there will be another opportunity for a work session for the commission to consider whether the rulemaking should be finally adopted. And at this time, I'd be happy to take any questions about the notice of proposed rulemaking. Thank you.
Are there any questions from the commissioners here? Commissioner Bukasek, do you have a question?
No, sir. Thank you.
I have one. Okay, a verified signature, would that just be an affidavit that they sign that this is my signature? Or how would that differ from some sort of an affidavit?
President Molnar, we were thinking that it would be a small section of the application saying, I affirm that the foregoing is true and correct to the best of my knowledge, and then a space for a signature. As a small update, staff is also planning to bring some updated motor carrier forms before the commission in the near future. So you'll have an opportunity to look at the final forms before they're posted online.
Further question, is there any reason it wouldn't be signed on an affidavit as opposed to a simple declaration that I'm not lying to you?
I think it makes most sense to have it be part of the application as opposed to a separate piece of paper. This way it'll just be together in one place for the protestant to complete the full form.
Well stated. Any further questions? Seeing none, do I hear a motion to accept staff's recommendation for the amendment?
Mr. President,
Yes.
I move to approve the draft notice of proposed rulemaking and authorize staff to make any non-substantive edits as required for publication in the Montana Administrative Register.
Thank you, Commissioner Fielder. We have a motion. Do we have a second?
I'll second.
We have a motion and a second. Is there any further discussion? All in favor of the motion will say aye.
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 Those opposed, same sign. The ayes have it. Now we have our legislative update. Commission initiated to discuss bills relevant to the PSC mission, statutory authority, administrative processes, and general agency concerns. Discuss the PSC budget request presentations, consider staff analysis and recommendations, provide directions for PSC response to bills. Take it away, Trevor.
Mr. President, commission members, this is going to be a busy update. It's a busy week this week. As far as an update on previous action, this morning in Subcommittee D, the committee voted 4-3 to not move forward the 2 FTE for the rail inspection program. That was kind of a last minute unexpected flip of a vote. Again, we lost by 1 vote on that one. The subcommittee also voted, they took up 2 of the 3 FTE requests. So they passed 1 FTE for the accounting tech and the half FTE for the administrative assistant for doc processing / public comment support. We still have 1 FTE pending. The package they passed today included the 1.5 to FTE, as well as the 200,000 for consulting funds. But there is still 1 FTE out there on the table. There's some questions surrounding that, I'm assuming, so I am getting on top of that. I did not realize they segregated that out this morning, but they did. It's not dead. They're just going to have some more questions for us, so I'm on top of it.
Trevor, Mr. President, question for Trevor on that one.
Commissioner Fielder.
Thank you. So Trevor, this other FTE that's still hanging out there, that's the position slated for regulatory compliance to assist with document processing and management of the small water dockets and telecom dockets and so forth.
Correct. It's the doc processing position, and I think there's some confusion because it's titled administrative assistant along with the other half FTE. So I think the committee is in need of some explanation as to what we need an extra 1.5 FTE for administrative assistants, what the purpose of that is. It's been explained, but we'll get on it and get a call in with the chair and try to get that over the line. I would anticipate they will, unless they're really sharpening their pencils this go. Further questions on this morning?
Are there further questions? Please proceed.
The rest of the legislative agenda, I'll be leaving here directly after this to go testify on House Bill 45 in the Senate Energy this afternoon. That's the last of our hearings on the legislative agenda. The Senate bills all passed House Energy last week, SB 22, 23, and 51. They're waiting on floor scheduling, so they should be up on the House floor soon. A particular note to the commission, House Bill 363, the commission appointment bill, is still waiting executive action in House Energy. We're anticipating that to come this week. There is no Friday meeting scheduled, so If it doesn't happen tomorrow, I know they're wrangling some amendments to adjust the qualification standards in that bill. If those don't get done, they won't do it tomorrow. But if they are done and satisfied with their amendments, they may take action tomorrow. That's an update of last week's relevant previous action. The rest of the monitoring bills are mostly in the Senate committee and they haven't taken action on them. We're watching for it. I would anticipate some executive action coming out of the Senate on Thursday. If there's no questions on that, we can jump into the new bills. And the two larger bills that we've been anticipating have both dropped and are both scheduled for hearing. So we put SB 301 in your packet. We don't necessarily need to go over it again. This was the LC we showed you last week. This is the transmission bill. I think the discussion we need to have today, given that this bill is scheduled for a Thursday 3 p.m. hearing, is this. We've been operating under the assumption that without further notice or discussion, I would function as staff rep to testify. Mr. President this morning made mention that he might want Lucas to go up on this bill and the liability bill. So we just need to make a plan as to who, what, and when on SB 301. You voted last meeting to monitor this bill and participate as an informational witness. My second question would be if that has changed in the course of the last week. And of course, if we need a refresh on what this bill is, I can certainly do that as well.
Just for clarification, I didn't say that I wanted Lucas to be up there. I said I talked to Lucas and I thought he wanted to be there and wanted to know if I was going to be there. So whoever you guys think would be best to present whatever needs to be presented. I have some problems with the bill myself. I was going to read it again before I got too deep into it, but it seems to me that, tell me if I'm wrong, that we're actually bringing back FERC 1920 back into this. Only the allocation is going to be done by Northwestern for anything that's not, that's left over in the need for allocation. Am I correct in that?
Mr. Chair, I wouldn't say it's exactly the 1920 process, but what the process does set up is kind of, to my understanding, a cost tracker in reverse, in which the utility would have the certificate of public necessity. And then in this process would set a forecast. And at the end of the 12-month period, we would true up the return. So they would get the rate of return for the 12 months. And then at the end of that process, we would hold essentially a rate case proceeding to readjust those rates based on the forecast provided and approved by the commission. So it's not exactly the 1920 cost allocation process per se, but it's certainly allocating costs on a 12-month period with the money up front looking forward, rather than a normal tracker process where you would have a base year and compare back to that. Also includes a quick turnaround for interim rates, and that's all in this section 3 of the bill.
So first I'll say, are there any other commissioners or anybody that would like to chime in on Senate Bill 301 at this point? Commissioner.
Mr. President, this is a substantial policy decision of the legislature. And I think that some of the just basic problems I see with it that would make it difficult are within the definitions where energy storage and energy generation are classified as transmission technology. And that just seems really problematic to me. I think that my suggestion would be that we at least point that out, that when we've had definitions included in statute in the past dealing with the regulated entities, and those definitions did not comport with typical industry standards, it's created a lot of confusion and substantial problems that we had to work to try to get rectified. So the rest of it is, in my opinion, a pretty major policy decision of the legislature. I don't want to wade into their territory too far, but it seems like at the very least, the definition should reflect typical industry standards and not be some unique, strange, Montana only definition of what transmission means.
You have a comment on that at all, Trevor?
Mr. President, I think the staff, as we've gone through this, does have some concern with the mixing of supply and transmission in this definition. It comes out of federal code. And certainly there are questions to be asked as to why you would include energy storage devices and distributed generation for essentially pre-approval in this process and make them subject to this rate recovery in Section 3. I think it's probably cleaner if energy storage and distributed generation are just taken out of that definition, because it seems to me the rest of the definition all applies to directly transmission technology.
And Mr. President,
Sure.
One of our practices in the past has been if we see problems with a piece of legislation that would make it difficult for us to, as regulators, do the work in a consistent manner, that we would oppose the legislation unless and until there was an amendment that straightened things out, added to it, and then the agency might change its positions if that were rectified. But I feel that we ought to oppose this until it gets straightened out, because I think it's a wreck right now.
Any other comment? Trevor, when we discussed this, I think in this room, perhaps walking down the hall, the fact that revenues and the costs associated were becoming unbundled seemed to be concerned that that we're running afoul of FERC and various federal regulators and regulation capacity. You still feel that way? Because the word unbundled applies to Section 2 sub A under new Section 3.
Mr. President, if it's helpful, maybe I'll just take you through the discussions we've had in the last week with different entities, because we definitely do have concern with the term unbundled. The sponsors are bringing language they think clears that up. Essentially, it's saying unbundled in a different way. Basically assessing the cost separately. We still feel like we're in a gray area on that front, basing the state's process on the FERC process. The stakeholders disagree and are essentially trying to, in this Section 3, mirror as closely as possible the FERC process in our process. I think, to be frank, the larger question with Section 3 is the process this creates at the commission, where essentially you're going to have a contested case proceeding under MAPA every 12 months to assess.
Where in Section 3 are you finding that?
Basically everything from 2 sub B down. Staff has some concern as to at what point the prudency review would occur. Staff has some concern and wants some clarity in 2B Roman 2 regarding construction work in progress language. And the larger discussion I was aiming toward here is this seems to create a process in which every 12 months, you're going to have a proceeding under MAPPA to evaluate the forecast against the actual returns and whether those are higher or lower than the forecast, then truing up to that forecast. And it's going to take time. It's going to take discovery. You're going to have intervener testimony. And it's essentially appears to be, and we may be wrong, but it appears to us that this creates a mini rate case proceeding yearly for the purposes of cost allocating transmission.
Do you have any idea where they want to build these lines? Are these, when they say customer, are they talking customers out of state? Or are they talking Northwestern customers, in-state, MDU customers, in-state?
Mr. Chairman, no. No,
No what?
we don't have an understanding of where they're headed.
Okay, the idea of an ongoing expense until it's done being recovered when it's supposed to be, to my humble way of thinking, more electricity perhaps than transmission, but used and useful until they complete it and it's being used. It's neither used nor useful, but they've collected a lot of money. Am I seeing a problem there that doesn't exist?
Mr. Chairman, I think that is the concern or a concern with doing the rate recovery up front and working off of a forecast.
Further question, who does the forecast?
In the bill, it is somewhat unclear, but I would imagine that the forecast is provided with numbers from the utility. And this is part of our question as to when prudency review happens and in what places. You would assume that a prudency review would occur of the forecast first to start this process. And then further, there would be, the contested case proceeding at the end of the 12-month period to adjust the rates based on the forecast in a true up form. And if I might, Mr. President, this is why I think in the initial discussion last week, we came out with the monitor for the moment decision, because there's still a lot of questions to answer. There's probably a lot of work to do in Section 3 to make staff feel comfortable with the process, maybe lining that process out in more detail in that Section 3.
I would have to admit that there's things about this that are fairly new. This seems to be a fairly unique approach. I can't rely on my experience. And correct me if I'm wrong, but in your discussions with various stakeholders, there's a lot of disagreement as to what some of these words mean. I'm not the only one that's confused by this. It just seems to me that the consumers are the ones putting up the money and picking up the risk for a transmission line that may not serve them. If it's going out of state, it's not going to serve them, but the cost would be on the Northwestern Montana customer. Am I correct in that?
Mr. President, ultimately, if you're going to rate base these transmission lines, yes, the customers would be paying for them.
But if they go to out of state?
Mr. President, I'm not clear as to the interstate transmission line implications. Largely, those are FERC rates set at the FERC level. So,
But if, and I'll give you an example here in a minute. So if this became Misty 2.0. And it's going to serve areas south of Montana. And the ratepayer in Montana is paying to build these and quite possibly picks up an allocation of some kind, perhaps reliability or something. It seems to me that there's a lot of risk here. I'll give you an example. I'll go back to Misty. One of the ETIC meetings, I said, I'm the guy that killed Misty, and their lobbyist said, you sure were. Well, the reason I took the approach that I did was in a deal cooked at FERC, you had Misty, which is supposed to deliver green energy to California. But part of that was 2 collector lines circling a good chunk of Montana to tie into wind farms to bring them down to be shipped out of Misty. FERC ruled, their order was that if this was a successful project, Northwestern had those collectors. If the project failed, Northwestern consumers picked up the cost of that. Then, I forget the technical term, we have a Northwestern person here, but there's a gizmo that actually bends electron flow. And they put that in at the Townsend substation was the plan. So that they could, as opposed to just to fill the line up and some go south, they could force it south. And these all tied in at Colstrip. So they could ship black electrons and green electrons. And if for some reason California said, we've got plenty, never mind, the cost for those collectors stayed with the Northwestern ratepayer. I'm seeing a lot of the same thought process here, but it's not spelled out. It's not clear. Consumers are at risk with this, I firmly believe, and somebody should be able to explain to me that that's not the case and put it in writing.
Mr. President, I think that's my point.
So, Mr. President, I think the question here is whether the commission wants to take a formal position against the bill or maintain a position to monitor and have staff appear as informational witnesses. If staff appears as informational only, then they may not be able to express the concerns that we've discussed here today. Because informational witnesses, as I understand it, are only permitted to introduce themselves in their area of expertise unless called upon to answer specific questions of committee members, whereas if they are in favor or opposed to a bill, they can state their reasons for their position.
I'm going to try a motion unless somebody else has one. That we oppose Senate Bill 301 until we have solid answers to these questions. And I'd like to empower Travis to write down what those questions are and what our concerns are. Whether Travis goes, Lucas goes, both of them go. I think I'll be there if not necessarily to testify, but for the purpose of if somebody wanted to ask me a question. So my motion is we oppose until we get solid answers to the questions that Travis is about to draft based on our conversation today.
I'll second your motion, Mr. President.
Motion has been made and seconded. Is there any comment or conversation on this? Commissioner Panucci.
This bill, you're discussing options with bill writer, is that right?
Correct.
There's some
Sure.
changes that are coming forward, we think, in the next day or two.
Potentially, yes. We haven't seen them yet.
I understand they're coming. I'm thinking we should wait until those changes become apparent what they are. Thank you.
Do we have a comment that we should wait? I think my comment back would be when they come about, we can change if we get answers short. We're opposing until the questions are answered, not verbally, but in writing. So if they bring forward some concepts, ideas, clarifications, federal law, court rulings, whatever they want to bring forward that give us confidence that the consumer is not being used in a way that is inappropriate. I maintain my position. Seeing no further commenters, all those in favor say of the motion to oppose until we get clarification, say aye.
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 And those opposed, same sign.
Aye.
4-1, motion passes.
Okay, Mr. President, Commissioners, we're taking these in order. This is a bill I just want to put on your radar. It creates a new criminal penalty for the assault on an employee of a public utility. This moved quick. It had its hearing this morning. Just want you to be aware, it's not really in our purview, but if there's any want to come in as a proponent on the other side, we could certainly do that. Simply makes a penalty and crime of assaulting a public utility employee specifically.
Mr. President,
Yes.
Trevor, just for clarification, is this a bill being heard by the Energy Committee or by Judiciary Committee?
Judiciary, it's outside the scope of our normal work, but it does involve public utility employees and probably stems from the incident in Missoula during. Yeah.
Well, thank you for the notice. I don't think we should take a position on this one, Mr. President.
Well, is it currently okay within the law to assault a utility employee?
Mr. President, that was my question. My first thought, probably not, but this creates a specific penalty and specific sentencing for that crime. Added protection.
Without a substantive motion, because this is outside of our purview, we will not take a position.
Okay, I promise the rest of them are directly relevant to the scope of the commission's work. The next bill is House Bill 490. This is the second of the larger bills we knew were coming. It has dropped and it is scheduled already. Quick turnaround from Friday for 8 a.m. tomorrow in House Judiciary. This is the wildfire liability bill that we've heard much about. I want to take you through very briefly. The bulk of the bill for us is Section 2. It creates the wildfire mitigation plan. It sets out a process similar to the IRP process here at the commission. And I want to very quickly point you to what could be problematic. On page 4, sub 5, this sets kind of the process. After a public meeting and no more than 60 days after the close of public comment, the Commission for a Regulated Utility shall identify any deficiencies in a wildfire mitigation plan and provide written comments addressing whether the wildfire mitigation plan is reasonable in the public interest and reasonably balances the incremental costs of implementing the plan with the risk of a potential wildfire. Another thing to note, once a plan is approved, it simply requires a submission biennially of a wildfire plan. A biennial report summarizing the provider's wildfire mitigation efforts and compliance with the plan from there forward. Doesn't require a review process per se after that initial one. Section 7 there allows the commission to appoint a technical master to determine the wildfire mitigation plan contains the required components in subsection 2, which lists all of the components. It is a bit concerning to me for this commission to take this on, given that we are an economic regulator. We have economists and accountants. We do not have forestry experts in the building. I think the sponsor's intent in allowing the commission to hire a technical master is to give you an option to hire an expert to run that process. in forestry management or whatever you deem the expertise you need, I would say that's going to require resources. And currently, there is no appropriation in this bill. The calculations for the fiscal note cite a number of $100,000 per mitigation plan for a technical master. That number could be slightly conservative. We don't have a lot of expertise in going out for that particular expertise. We based it on a prior case in which the commission used a technical master. The rest of the bill is largely the liability treatment based on the approval of a wildfire mitigation plan. You can look through this. It is basically providing that electric facilities providers have an obligation to serve the public, and a standard of strict liability may not be applied to an electric facilities provider. Essentially, if they have a plan and are following the plan, it raises the bar for negligence based on the plan and the proper implementation of the plan for the company. It touches on rebuttable presumption and provides several more protections for the utility if the plan exists. It's my view that really that new section 2 or new section 3, excuse me, is more for the insurance companies to fight over than us. Our focus in this is if they're going to give us this duty, we need to have the resources because it does shift risk from the utility to state government in the fact that we have to make a determination and do a prudency review per sub 5 on page 4 to determine whether their wildfire mitigation plan and activities are prudent. There was some discussion around having the commission simply approve or deny whether the plan included all of the information needed. To me, with this language of in the public interest in the bill, you're on the hook for a prudency review of their practices.
Commissioner Wilbur?
Thank you, Mr. Chairman. And with the absence of a fiscal note, but if I understand part of what Trevor's concerns are, the cost of having a specialist on staff could be it could pale in comparison to if one of these was litigated and the state of Montana's on the hook, whose budget does that come out of? Is that general fund budget or does it come out of our budget? I think that's, a question that is in my mind is, in the event of it being litigated, somebody's going to be on the hook. So is that the ratepayer via the commission, or is it going to be the taxpayer via the general fund?
I don't think it comes out of your retirement pay. So, but can you answer that? Because I can see, I'll tell you my concern, and you can perhaps answer both at the same time. The reason that this is such a big deal nationally, to where NARA calls it the biggest issue out there, is the courts have ruled that utilities were wrong to shut off electricity due to fire concerns during high wind events. And there were some massive payouts. They have ruled that they were wrong to not shut them off. However you go, you're wrong. So his question, Commissioner Wellborn's question, I think is answered, and please correct me on this, but they're going to sue everybody they can think of to sue. It's going to be the state of Montana. Public Service Commission didn't do their job. and whoever else they can find. If we ever had a fire, anything like the campfire fire, 85 dead people, $18 billion in losses, the airport would be clogged with attorneys coming in here to sue somebody on that. We would all get sued. So if you could address that, and then do you see that we would need this specialist, maybe $100,000, whatever it would be, to help us review their plan? Or does he stay here? Because if we get sued, we're going to need more than one.
Mr. President, I'll take a stab at that first. The way the bill is set up, giving you the ability to appoint a technical master, it would be probably more convenient to have a temporary consultant type do that work. Given that this is a biennial requirement post actual filing of a mitigation plan, I don't know that you can make enough work for a forestry specialist at the Public Service Commission over the whole of a 2-year cycle. So that's probably more likely the way it would go practically. Of course, this is all subject to the commission's wants on that front. So there's that. I do think it would probably come in the form of outside consulting. On the second front, in the scenario you laid out, Mr. President, I think we would need far more resources in our budget to fight a litigation proceeding of that caliber. So it would be very likely that, to me, we would be turning to a supplemental budget action to get more money and represent ourselves, or turning to the Department of Justice and the Attorney General for outside counsel to represent the commission in a proceeding that large.
To answer your question, Commissioner Miller, I have one. I'm amazed that the PSC is in this. Has any consideration been given to DNRC? They have fire behavioralists. They have people with years of experience. We don't have any of that.
Mr. President, Commissioners, it's my understanding that DNRC was a part of the early discussion and did not want to be the landing spot for this particular piece of legislation. Certainly not part of the discussion now.
Mr. Panucci?
Couple of questions. Do the utilities support this bill?
Mr. President, Commissioner Panucci, I would assume so. We'll find out at the hearing in the morning officially, but yes, I would assume so.
Do you think they support the bill because they're getting out of liability to the fire?
Mr. President, Commissioner, I don't want to speak for the utility. But I think, the conversations around this bill is this is a tool to protect the utility from liability, given the situation that President Molnar laid out, in which utilities in the West have been sued several times in different states for either causing a fire on one end or improperly shutting off power on the other. So I think you can take from that what you will, Commissioner.
My final question would be, in your opinion, how does this help the ratepayer? Or if this bill passes, it would hurt the ratepayer?
Mr. Chair, there is probably an argument that given the protection on the ratepayers' one hand from liability in the event of a large fire, it would help by preventing those costs. On the other hand, it could shift the risk and create large costs on the taxpayers' front at the commission in the event that the risk is shifted and they find the state negligent in its process for review of one of these plans.
Did that answer your question, Commissioner? Okay. Commissioner Fielder, please.
Thank you, Mr. President. So tackling this matter of wildfire liability is certainly needed, necessary after what we've seen with some of these other cases and utilities. The risk to the utilities that are involved with the subject, but I do have some concerns, and that is the way I haven't given this a thorough reading yet, Trevor, but is it my understanding, correct that a utility would submit their wildfire plan to the commission if they're a regulated utility, and to the electric cooperative board if it's not a regulated? So the commission and the electric cooperatives are expected to have the expertise to be able to judge whether a wildfire mitigation plan is sound or not, and to monitor whether or not is being followed properly. Is that correct?
Mr. President, Vice President Fielder, correct. And the reason I say that, and it's an important distinction, is what still lives in this bill is line 7 of page 4 that says, provide written comments addressing whether the mitigation plan is reasonable, in the public interest, and reasonably balances the costs of implementing the plan with the risk of a potential wildfire.
Yeah. So this seems like a tremendous and misplaced burden on economic regulators to be making this judgment call regarding wildfire risk. I could see it if it was strictly in relationship to the operations of the utility and mitigation that was taken to avoid transmission lines causing wildfire. But there's a number of things that could be involved in a wildfire. And I'm disappointed to hear that DNRC wasn't interested in taking a role in this. I think if the state were to take a role in it, it should be with Department of Natural Resources, as President Molnar pointed out. So I'm not sure what to do with this piece of legislation. I have not given it a thorough reading, but that's my initial take on it. Is if the legislature decides this is good policy for the state, and I see some sponsors on here that I think it's got bipartisan support from looking at the sponsor list, so it may very well pass. But seems to me, and we do need some protections in place so there's not frivolous lawsuits against the utility, and so that the utilities aren't bankrupted when they've done due diligence and done what they can to prevent catastrophe. I'm not sure what the answer is, but I don't think the answer is for the economic regulators to be responsible for making decisions that are well outside of their expertise, unless the state wants to provide resources to all of the utilities that have to make these decisions, and that doesn't seem very feasible to me as well.
Any further questions or comments from commissioners?
Mr. President, I suppose the decision here again is similar to the last piece of legislation that we discussed, and that is whether the commission should maintain a neutral stance and appear as informational, or if we should take a stance so that we can express our concerns with it.
Well, that, of course, is the question. In my view, I'll just throw this out there. Since I've been a watcher of the PSC and I'm a member of the legislature, they have tried to give the PSC the authority for delivering marijuana in taxi cabs. Never mind, it was a federal crime to have it in your taxi cab. They wanted us to have oversight on social media. Never mind nobody had any idea what that meant. And this seems to me to be that DNRC said we don't want it, and somebody said give it to the PSC. If I might be so bold, if you could work this into whatever position we take today, if you could work it into your conversation, in the halls or at the podium, that if DNRC were to be a part of the original planning of this, that would be great. But we don't think the entire state of Montana should ever be a litigant in this. Lightning strikes happen and we don't know how the courts are going to go. But in the final analysis, Northwestern needs to come to an understanding and agreement with their insurance company to go forward with the plan that DNRC says we think this is the best we can do. I think carries some weight. Public Service Commission saying the exact same thing. I don't think carries any weight. So Commissioner Fielder, did you have a motion to make?
Mr. President, I'll move to oppose the legislation on the grounds that economic regulators simply do not possess this expertise. And the expertise would be, the decision or the review process would be better placed with an agency that holds the expertise.
We have a motion. Is there a second?
I'll second.
We have a motion. We have a second. Is there any discussion on the motion to oppose?
Call for the question.
Question's been called for, non-debatable motion. All in favor, say aye.
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 Opposed, same sign. Ayes have it. We oppose being involved in this at all. And if you can make it clear that that's our only objection, we're not getting into the rest of it. We're just not there. So with that in mind, do you have anything else, Trevor?
Mr. Chair, just a brief discussion of the plan for that one tomorrow morning. Would you like to come along and testify, or do you want me to deliver that message?
If at all possible, I'll be there.
Okay,
I don't know, other than what we've discussed today, I wouldn't want to go much outside of that.
correct.
But I think we're pretty clear that, you know, you're not picking your best option.
Okay,
What time is this one scheduled?
8 a.m. Room
In room-
137, House Judiciary.
137?
Yes.
Oh, this one's in judiciary also, huh? Oh,
Yep.
I guess so, would be. Okay.
Okay, the next two bills both involve Class D motor carriers. House Bill 517 is a forward change in sub 2 of the Class D motor carrier PCNN. You find the change on line 17. Essentially, what this is doing is allowing a motor carrier to possess a Class D license if they intend to engage or actually engage in the transportation of garbage. The prior language just says actually engages in the transportation of garbage. It's my impression this is a move to try to open up the discussion to folks who want to obtain a PCNN, but haven't quite established the actual business to do that yet. It moves that requirement, loosens it up to allow for someone who simply intends to engage in garbage hauling to acquire a PCNN rather than one who actually engages in the transportation of garbage on a regular basis.
Mr. President, this brings back some memories of some regulatory work that we've done in the past where companies that may be expanding or even new companies start advertising that they're going to do this. So it allows us to step in and ask them to obtain the license if they're intending to perform that type of service. So I think it's probably adds some clarification to it so we can address when we see advertisements, because I think we're kind of stuck where if there was an advertisement, we really didn't have jurisdiction until they actually started carrying it. And that seems a little bit like, playing catch up when we could be more proactive in working with the companies to help them understand how to obtain their license and not get in trouble after the fact. So it seems like it makes sense to me, Mr. President.
Any further comment? Seeing none, do I hear a motion?
Mr. President, I'll move to support House Bill 517.
Any further? Is there a second? I'll try to sing it correctly. Is there a second? I will second. Is there any discussion? Seeing no discussion, all in favor of the motion to support signify by saying aye.
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 Those opposed, same sign. Ayes have it.
Okay, House Bill 518, also a Class D motor carrier bill. There's one change in this bill as well on line 24. And essentially, it strikes Class D carriers from the section that allows for a denial of a PCN without a public hearing. So the net impact would be if we are to deny a PCN, we have to hold a public hearing in order to do so.
Trevor, do you have any idea why this bill is being brought?
Mr. Chair, no.
So you're saying the bill says if we're going to deny a PCN, we have to have a public hearing?
Sure. Line 24 reads, an application by a motor carrier pursuant to 6912-311-1B currently reads, or by a Class D motor carrier for a certificate of public convenience and necessity may be denied without a public hearing when the records of the commission demonstrate that the route or territory sought to be served by the applicant has previously been made the basis of a public investigation and finding by the commission. The bill simply strikes Class D motor carriers from that provision. So regardless of a prior record, prior hearings, if you're going to deny a Class D motor carrier PCN, you have to have a public hearing to do so.
Trevor, would it be, am I wrong in thinking this would be the second hearing on that same PCN? We've already done an investigation. Certainly we had something.
Mr. Chair, that's kind of what the language surrounded. If you had already done a proceeding, say our typical hearing in considering granting a PCN, then you wouldn't have to have a public meeting to deny that PCN.
But now we would.
Now you would.
Mr. President,
Yes.
this is speculation on my part, but by looking at again, the sponsors, particularly the two leading sponsors on this, these are sponsors who have in the past introduced legislation to abolish the requirement for Class D PCN licenses. So I think my speculation leads me to believe that they just want some added public opportunity for the public to weigh in on whether a license should be denied or not to a hauler, which I don't have any problem with. I think because the typical hearings that we have on these cases are not necessarily public hearings. They're open to the public, but it's for the contested parties to present their witnesses and their arguments. And this seems to me, correct me if I'm wrong, Trevor, that this would be going at a more public hearing in the sense of the public coming and stating their views on the decision. Is that correct, Trevor?
Mr. President, Vice President Fielder, yes, it is a public hearing. I think the distinction can be found with line 27, made the basis of a public investigation. That specifically leads me to believe that this would not only, this doesn't only include applications and approvals, it would also include situations in which you're investigating publicly Class D garbage haulers and then making a determination to withdraw that PCN. I think that's what this sub 3 is actually aimed at, but the effect would be if you deny it, you would have to have a public hearing to deny it.
Okay. I've got no problem with this piece of legislation. I think it just gives the public more process.
Further comment?
Mr. President, I'll just move that the commission serve as a informational witness and have Trevor be our designee for that.
Is there a second to the motion to make Trevor be our informational witness on this matter?
I second.
Commissioner Bukasek seconds. Is there any discussion on the seconded motion to allow Trevor to be our informational on this matter?
Call for the question.
Question's been called for. It's non-debatable. All in favor will say aye.
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 And those opposed? You guys have it.
Did you vote, Mr. President?
Sometimes it doesn't work.
Or was it 5-0 or was it, okay, 5-0?
Okay, last one is a House joint resolution. Pretty simply, as you read through this, it's a joint resolution in support of the tremendous economic benefits, and I quote, that renewable energy projects have brought into the state, and further recognizes the potential for future economic benefits from new renewable energy projects. As such, the legislature supports the future responsible development of renewable energy projects in Montana. Given that we might get some public comment down here on that resolution, I wanted to make sure it was in front of you. It's scheduled for hearing Thursday, or excuse me. It was scheduled for hearing tomorrow. It was canceled. Not sure of the status of this one now, but probably one to monitor for the commission.
Mr. President, I would concur with Mr. Graff's recommendation to monitor and not wade into this. I think there'll be a lot of debate at the legislature, and that would be the proper place for it, and not jeopardize ourselves potentially being drawn into accusations of bias one way or another.
We have a motion to monitor. Do I hear a second?
Second.
I have a motion to monitor. I have a second. Is there further discussion? I concur with the motion. All in favor, say aye.
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 And those opposed, same sign. 5-0.
Okay, that's it for new bills. Did you have a question, Commissioner?
I wanted to ask about Greg Kometz's bill, but I think that's what you were going to next.
Mr. President, it wasn't what I was going to next, but
Up to you.
If the commission would like to discuss Commissioner Pinocchi's additional item, that's up to you, Mr. President.
How far along is it?
It has a House hearing, I believe, if it's the item I think it is.
Oh, was it like HJ 15 that was discussed yesterday in energy? And I testified on the bill.
Mr. President, Commissioners, HJ 15 is a resolution supporting the development of transmission broadly in Montana. Commissioner Pinocchi, I'm not certain what your motion is.
Well, let me just, I think I've got a little bit of an idea of this. So was this the Representative Kometz's resolution to support pursuing innovative technologies in transmission in the state of Montana? Is that what that was?
Yes.
Yes.
Okay. And was it limited to carbon fiber conductors, or was it broader than that?
Mr. President, Vice President Fielder, no, it broadly just supports the development of transmission holistically in the state.
Okay, thank you.
I would like us to discuss that bill. And also I'm going to make a motion for this commission to support that bill.
We have a motion to support Kometz's resolution. We have a number of that.
HJ 15.
HJ 15. All in favor, say aye.
Whoa, whoa, whoa,
Whoop, whoop,
whoa.
whoop. Is there a second? How's that?
There would need to be a second.
Yeah. Is there a second?
I'll second so we can have the discussion, Mr. President.
We have a motion, we have a second. Is there discussion?
Mr. President, yes, and Commissioner Pinochi, this is something that you're, I think, passionate about and have been pursuing. So I defer to you. I would like to see the legislation though before we're asked to take a vote on it.
Mr. President, Commissioners, if I might, if that is the case, it just had its House hearing. It looks as if it's going to probably pass in that committee. We do have another bite at the apple on the Senate side. So we could make that an item for the next update if that's the will of the commission, if need be.
Would Commissioner Pinochi be willing to withdraw until we've had a chance to look at the legislation, given that we've got time, the hearing's already happened?
Yesterday, I testified on the bill and we had a lot of discussion. And it was a very popular bill. There was no one that stood against the bill. My district is very clear that we need more transmission and we need more distribution, which is lines between transmission and the home. And it's holding up construction projects. So yesterday I said that I made it very clear that I was testifying in support of the bill on behalf of myself. But I did say that I was going to bring it to the commission to support today. So I'm okay to give us some time, but I want to make it clear my goal was to do what I said I was going to do yesterday, which was bring this to the commission to vote on today. But I do think it is fair that commissioners should have a chance to look at it. So I'd like to bring the motion up at the very next hearing. Thank you.
So just as a point of clarification, then you're withdrawing the motion for today?
I will do that if the commissioners think they need time to look at it, but it is a very straightforward motion and a very easy one to support. So if you want me to read it throughout, I will, but if you're comfortable voting on it today, I would like this bill to go forward with our support as soon as possible. Thank you.
I think Commissioner Wellborn's got his hand raised.
Thank you. And I personally would be more comfortable at least having a chance to look at the whereas clauses, even though it is a resolution. And I think that in my mind, the more before I can take a responsible approach to this, I would like to have a chance to look at the whereas clauses to make sure that there were, no unintended consequences that could come back and bite us in any way. So I appreciate you with your pulling back, and I take a look at it and decide next time. Thank you.
I'm sorry, Commissioner, but you can't have it both ways. Do you want to wait for a second? Or, I mean, to have a vote that we oppose or monitor or whatever, or are you withdrawing your motion?
What I said was I'd withdraw the motion if that's what you guys would like, but also we could vote on it today. But if the concern is that you want to take time, that's fine with me. But then I kept my promise that I made the motion today. Thank you.
Okay, the motion has been withdrawn. Do we have further business?
Very briefly, I have 6 minutes before I have to go up to House or Senate Energy. The hearing schedule for the next few days this week is tonight at 3, Senate Bill 283, establishing wind tower height and lighting requirements, saying that wind towers cannot exceed 350 feet is up, as well as SB 294, requiring public utilities to plan for 100% renewable resources and greenhouse gas emission reductions, as well as the commission's telecoms deregulation bill, which I'll be testifying on for us this afternoon. Wednesday, of course, again, room 137, the wildfire liability bill at 8 a.m. in House Judiciary. Thursday, in Senate Energy, it's SB 301, the transmission bill we discussed at 3 p.m. in room 405, as well as House Bill 55, which you'll remember is the Select Committee on Energy Resource Procurement and Acquisitions, IRP process modifications, and independent evaluator in the request for procurement process bill. That bill is still on monitor for us, so we'll be doing that on Thursday unless otherwise directed. That's the schedule for the week. Currently, there is no Friday House Energy. That might change here overnight. Bills are starting to come in quickly now. So, Mr. President, that's all I have for today.
Thank you, Mr. Graff. Is there any further, I'm sorry, is there any further business to come before this commission? Okay. The next business meeting is scheduled for 3/4/25. Next week is canceled due to NARUC. Therefore, seeing no further business to come before this commission, for the record, the time is 2:42 p.m. and the date is 2/18/25. This meeting is adjourned.
Thank you, sir.